Hello, welcome to the webinar today from Moore Ingram Johnson Steele. My name is Stephen Steele. I'm a divorce lawyer here in Marietta, Georgia, and I'm the senior partner here in the Domestic Relations Department. Today I want to talk to you about a few of the many current topics related to surveillance and investigation, especially within the context of domestic relations matters. Let's consider a hypothetical example. Let's suppose that you have sensed some friction in your marriage, maybe, or suppose you know of a friend, a coworker, or a neighbor who is going through a divorce. Let's say you go out to your car and for some reason you start looking underneath the dashboard. Maybe you lost your keys, you're looking for the source of some kind of noise, or you're trying to change a fuse, I don't know, whatever it is. But on the steering column, you find two box-like objects that are secured with a plastic lock tie to your steering column, and they do not look like they were installed by the manufacturer. Chances are pretty good that you want to know what they are, and you also want to know who did this. Well, let's suppose that you determine that one of them is a voice-activated audio recorder, and the other one is a GPS tracking device. You're going to want to know who did this. You're going to want to know, is it legal? You're going to want to know, are any of the conversations that were recorded by the audio recorder going to be admissible at court? And you're also going to want to know, is any of the data gathered by the GPS tracking device admissible in court as well? And probably you also want to know, can I sue whoever did this? As I'll discuss with you, who installed it will make a difference. It could have been the police, it could have been your employer, especially if you're driving a company car. As we'll discuss, it could have been your spouse, or actually it could have been anybody else. If you're able to determine that either one of these devices was installed by the police or other law enforcement, then the constitutional protections of the Fourth Amendment are now triggered. The Fourth Amendment says this: the right of the people to be secure in their persons, houses, papers, and effects is an important word there, against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, in particular describing the place to be searched and the persons or things to be seized. In the case of U.S. v. Chadwick, that was a U.S. Supreme Court case from 1977, the U.S. Supreme Court held that a vehicle is in effect within the meaning of the Fourth Amendment. So to search a vehicle, the police must have probable cause. If the police install the audio recorder, there's a Georgia statute, it's OCGA 161162, that states that it is unlawful for any person, including police, in a clandestine manner to intentionally overhear, transmit, or record, or attempt to overhear, transmit, or record the private conversations of another which originate in a private place. OCGA section 161169 makes this a felony punishable by 1 to 5 years imprisonment or a fine not to exceed $10,000. And of course there are exceptions which allow these recordings that are otherwise unlawful. For example, sheriffs are allowed to record activities of persons in their jails. Owners of property can use security cameras, and police can use body cameras. OCGA section 161164 allows an exception to law enforcement officers who first obtain what's called an investigation warrant. And the investigation warrant is a term of art. If they get an investigation warrant from a court which permits the use of such device, then that recording that would otherwise be unlawful is lawful. Assuming the police obtain such an investigation warrant, then the police did not commit a felony, and the recordings from the audio recording device placed in your car are going to be legal and admissible in court. And if the police install the GPS tracking device, here we have an applicable Supreme Court case called U.S. v. Jones, the U.S. Supreme Court. In U.S. v. Jones, the police, without a valid search warrant, attached a GPS tracking device to the undercarriage of a Jeep that was normally driven by Antoine Jones, but curiously was registered to his wife. The installation occurred while the Jeep was in a public parking lot. Over the next 28 days, government agents used the device to track the movements of the vehicle, and once the police even replaced the battery while the Jeep was parked in a different parking lot. The GPS tracking device relayed more than 2,000 pages over the next 4 weeks. Justice Scalia, the late Justice Scalia, wrote the opinion of the court, and he held that the placement of the GPS tracking device was an unlawful and warrantless search under the Fourth Amendment. Placement of the GPS tracking device on your car, if by the police, was probably preceded by the issuance of a search warrant. And as long as the search warrant was valid, then the evidence and the information obtained by the GPS tracking device is going to be admissible in a criminal prosecution. Now, in determining what constitutes a search, courts look to whether there was a reasonable expectation of privacy in the area that was accessed by the police. If there was a reasonable expectation of privacy in the area accessed by the police, then there was likely a search within the context of the Fourth Amendment. However, if there was no reasonable expectation of privacy, then the intrusion by law enforcement is less likely to be considered a search. Now, Justice Scalia acknowledged what is maybe the most compelling argument in favor of allowing these GPS tracking devices, and that is, the driver of a vehicle has no expectation of privacy as to the location of the vehicle when the driver of the vehicle is operating the vehicle on public streets, accessible and viewable by anybody. Justice Scalia also acknowledged that there's no realistic expectation of privacy in the undercarriage of the Jeep that Antoine Jones was operating where the GPS tracking device was installed. Now, consistent with this line of thinking, the 2010 decision of DeVega versus State by the Georgia Supreme Court had Justice Carley writing the opinion for the majority of the Georgia Supreme Court. He quoted a U.S. Supreme Court case called U.S. versus Knotts, which held that a car has little capacity for escaping public scrutiny. But in U.S. versus Jones, the opinion that Justice Scalia wrote, he distinguished U.S. versus Knotts, and he noted that unlike Jones, the monitoring device that was used in Knotts had already been installed within a container when it first came into the possession of Knotts. Jones, on the other hand, had the device installed after Jones already was in possession of the vehicle. Justice Scalia held that where the government obtains information by physically intruding on private property, whether or not damage occurs, and where that intrusion is conjoined with an attempt to find something or obtain information, then a search within the context of the Fourth Amendment has occurred. The interesting opinion by concurring Judge Sotomayor says this: physical intrusion is now unnecessary to many forms of surveillance. With increasing regularity, the government will be capable of duplicating the monitoring undertaken in this case by enlisting factory or owner-installed vehicle tracking devices or GPS-enabled smartphones. Disclosed in the GPS data will be trips to the of an indisputably private nature of which it takes a little imagination to conjure. Trips to the psychiatrist, the plastic surgeon, the abortion clinic, the AIDS treatment center, the strip club, the criminal defense attorney, the by-the-hour hotel, the union meeting, the mosque, the synagogue, the church, the gay bar, and on and on. And those are the words of Justice Sotomayor. So what's interesting and what's very circumspect of Justice Sotomayor is she says that if this analysis by Justice Scalia that requires some kind of physical intrusion is going to be held up to rule out the admissibility of GPS tracking device, we're going to need some other form of analysis, because truthfully, the kind of GPS tracking that was done in Jones is not very far from being possible without any kind of physical intrusion on the vehicle. So in conclusion, if the police installed the audio recorder, the police should have obtained an investigation warrant. If the police installed the GPS tracking device, the police likely obtained a search warrant. But only the police can obtain an investigation warrant under OCGA 1611-64, and that's to install the audio recording equipment. The individuals cannot, without some kind of exception, install the audio recording equipment. Otherwise, that's a felony. Also, the Fourth Amendment in U.S. versus Jones apply only to the conduct of police officers, not to spouses, not to employers, not to other non-law enforcement personnel. Non-law enforcement personnel need not and cannot obtain a search warrant. Whether or not installation of the audio recorder and the GPS tracking device were lawful, and whether or not the information obtained from the use of these devices can be used in court by your spouse is determined by statute, not by the Fourth Amendment. Now, curiously, unlike installation of the audio recording equipment, there is no statute here in Georgia that makes it a crime, I said a crime, to install a GPS tracking device on an automobile. And that's any automobile. Yours, mine, anybody's. However, unlike Georgia, a number of states have enacted statutes to criminalize the use of electronic GPS tracking devices without the consent of the owner. Some of these states include California, Delaware, Illinois, North Carolina, Tennessee, Texas, and Wisconsin. Even if your vehicle is owned by your employer, conversations that you have in the vehicle that you normally drive will probably be regarded as private conversations in a private place. But there may be an employee handbook or other guideline published by your employer that says otherwise. Now, assuming that the conversations are in fact private conversations in a private place, then placement of the audio recording device is likely a felony under OCGA section 1611-62, and that says it shall be unlawful for any person in a clandestine manner intentionally to overhear, transmit, or record, or attempt to overhear, transmit, or record the private conversation of another, which shall originate in a public place. Also, the Code section 1611-67 says that any device obtained which violates this criminal statute shall not be, any evidence obtained which violates this criminal statute shall not be admissible in any court of this state, except, of course, to prove violations of the statute. So the audio recordings are going to be inadmissible. As to the GPS tracking device, it is probably pretty likely that your employer, if it's an employer-owned car, told you about this. If your employer did not tell you, then as we discussed earlier, installation of the GPS tracking device without your knowledge or consent is not presently a crime here in Georgia. Now, let's suppose that these devices were installed by your spouse or by someone else. Well, if installed by your spouse, the statute we discussed, OCGA 1611-62, does not have an exception for spouses. It's still a felony, punishable by 1 to 5 years, and a fine of up to $10,000, even if a spouse in a clandestine manner tries to intercept the private conversations that you have in a private place. In the case of Ransom versus Ransom, the Georgia Supreme Court, with Justice Gregory writing for the majority, held that such recordings are not admissible when the husband attempted to enter them into evidence in the trial of his action for divorce. Simply stated, you're not allowed to record private conversations of another person which originate in a private place if you're not part of the conversation. If you are part of the conversation, then you can lawfully record the conversation, but it's a conversation to which you're not a party. Recordings of those conversations are felonies. And OCGA 1611-67 applies to make any recordings inadmissible in court. Now, let's say that the devices were installed by a third person. If the audio recording device was installed by a third person, like a private investigator or a suspicious spouse of a coworker, and neither you, your spouse, or anyone else with authority gave permission to approve such installation, then likely this third party has committed some kind of burglary by entering into your garage of your house, or even just your car if it's parked in a public place, for the intended purpose of committing the felony of lawful interception of a private conversation in a private place. If the burglary is of a dwelling, then the punishment is 1 to 20 years for the first offense. If the burglary is of an automobile, then the punishment is 1 to 5 years. However, the mere fact that the evidence was obtained through burglary does not provide a basis for the exclusion of the evidence at trial. In addition to burglary, installation of the audio recording by a third person is pretty clearly a felony under the same statute that we discussed earlier, that's 1611-62. The recordings are not going to be admissible into evidence, and you likely will have a basis for a civil lawsuit for invasion of privacy. Now, compared to old-fashioned video surveillance, GPS tracking devices are far less expensive. It does not consume nearly as many man-hours. From what I can find on the internet, a GPS tracking device could probably be found at a cost of not more than $400 or $500. They can be web-based and track in real time, or the data can be stored on the device, but that's going to mean that you'll need to retrieve the device back in order to download the information. The devices can be battery powered, they can be wired into the vehicle's electrical system. Subscription services seem to run between $20 and $40 a month. Most private investigators are going to tell you that the automobile must be titled or leased in the name of your client, of his client. Sometimes the private investigator may tell you that the vehicle just needs to be marital property regardless of how it's titled. Most private investigators will probably tell you that they need to attach the device on public property, probably to avoid being arrested for trespass. Now again, there's no Georgia statute that prohibits or even places a reasonable limitation on the installation of the GPS tracking device. Anybody could place a GPS tracking device on anybody else's vehicle, as long as there's not a burglary or a trespass. And if that's true, then there's no crime. In 2009, the Georgia General Assembly attempted to pass what was called House Bill 16, which is intended to amend the existing Georgia Code and to provide that no person shall use a tracking device to determine the location or movement of another person without that person's consent. The bill was not passed. So whether the GPS tracking device was installed by your spouse or by a third person, there is no statute here in Georgia which makes installation of the device a crime. Also, the Fourth Amendment prohibition in U.S. v. Jones is not applicable to your spouse or to third persons because U.S. v. Jones and the Fourth Amendment apply only to law enforcement. So it looks like installation of the GPS tracking device, unless done by burglary or damage, is not going to be a crime. Even if installed by burglary, the GPS data is going to be admissible in court. However, if the GPS device is installed by your spouse or some other third person, then you may have a basis for a lawsuit for invasion of privacy. Against your spouse, such a lawsuit is going to be difficult to win due to the doctrine of interspousal tort immunity, which admittedly has been eroded to some extent over the last several years. Now, if the GPS tracking device was installed by a private investigator employed by someone other than your spouse, maybe a jealous or a suspicious coworker, your lawsuit for invasion of privacy is probably likely to be more successful. For a good discussion, you can see an order that was entered by Judge Robert Leonard here at the Superior Court of Cobb County in a case called Melissa Atkins versus TFP Company, LLC. And he has a great discussion about use of and installation of GPS tracking devices. Additionally, if you can prove that the installation of the tracking device was for the purpose of harassing or intimidating you, then you may have a basis for a protective order and a subsequent criminal prosecution under the Georgia stalking statutes, but that's going to impose no money damages for you. So in summary, unless the audio tracking device is installed by the police, the installation is likely a felony. The felonious recordings are not going to be admissible at trial. But as to the GPS tracking device, if installed by the police, then there likely was a search warrant issued. If installed by anybody else, then no crime was committed, although you may have a basis for a lawsuit for invasion of privacy. The GPS data is going to be admissible at trial. Many have suggested the Georgia Assembly needs to enact a statute to regulate use of GPS tracking devices. I think you can see why. Thank you for this opportunity to talk to you. If any of us here in the Domestic Relations Department at Moore Ingram Johnson Steele can be of assistance to help you through this difficult time of divorce, I'll be flattered if you call on us. Thank you very much.